Hello, and welcome to the Bastine Brief. I am Ronique Bastine Robinson, owner of the Bastine Law Group. I am joined today for the third panel discussion with my friends and colleagues, Katie Custer, Yasmin Cuddy, and Misty Dennis. We today are going to talk about high-profile divorces. So let's just jump right in. What immediately changes in legal strategy when a divorce becomes high-profile or publicly sensitive?
We were talking a little bit earlier, but I'll reiterate, Facebook becomes and social media becomes a pretty big enemy to people who are already in the spotlight. And so having a discussion with your client about the importance of perhaps staying off of social media. And I've even had cases where we've sought an injunction from the court under a temporary restraining order, keeping both parties off, especially when children are involved.
What about you?
I think having a staff meeting, talking to people in your law firm to make sure privacy is protected. People should not be discussing the case outside the office. Controlling the use of social media, and also figuring out what the strategy is going to be for the firm about media. If there's any press inquiries, how to handle it, not handle it, what does your client want, possibly leveraging it to help your case or hurt your case, those kinds of things.
I like that about talking to the staff because we had a receptionist once and we had a high profile client and he came in and she recognized him and the first thing she did was fangirl. And I thought, I feel a little mortified right now. Misty, what about you?
I'm pretty much the same, making sure that you have the hard conversation with your client also about sharing information, about talking to friends and family members, because it may not be them who's doing the posting. It could be a friend of theirs who's doing the posting. And it's not even just about posting about the case, but their personal things that they're posting, the photos of themselves that they're posting, or making undermined comments on the other party's website or posts or whatever it is. Just keeping it confidential, letting them know, make sure they're keeping it confidential, and then strategizing about how moving forward you're going to keep the legal proceeding as confidential as possible, scheduling court dates and trying to get on dates where it's not going to be an 80 case docket, or thinking about doing arbitration or thinking about mediation and thinking about ways to keep the case out of the public eye.
And written communication too. I think that holds true with every client that we have, but the written communication and even phone calls, people are audio taping phone calls and stuff, but just a reminder to the clients and about just how this stuff will come back to bite them. And I always advise clients that, any text message or email that you send, imagine reading it in front of a judge. And if you can't do that without being embarrassed, then perhaps you should rephrase it.
Right.
I think I should listen to my own advice sometimes, but...
Yeah, I said the same to a client when asked, can I still talk to my spouse? And I said, you can talk to your spouse all you want. However, just remember that anything that you say to your spouse in that conversation could potentially be recorded and you could potentially hear that in front of a judge. So careful about what it is that you say to your spouse. I'm not one of those lawyers who tells my clients, don't talk to your spouse. I feel like you've been talking to this person way longer than you've known me. So sometimes I think they can make more progress than we can.
It's true. It's being careful about that stuff getting publicized. So it's just an added layer of that exposure out there.
Right, absolutely. So what legal tools are most effective in protecting client privacy in high-profile cases?
I know I was talking to Katie earlier a little bit about this, coming up with different ways to do the divorce. So, for example, there's collaborative law, using the collaborative process where parties retain attorneys, you meet in group settings, either via Zoom or in person. You get a joint financial expert and maybe a licensed therapist. as part of those meetings. I'm kind of watering it down, and you meet, you agree to do the collaborative process, follow it with the court, kind of stays everything, and then you keep, quote unquote, all the dirty laundry out of the courtroom, all your personal business out of the courtroom. And it works if everybody's transparent and can kind of cooperate, and you negotiate over a period of months, maybe even a year, and you get an agreement that can be filed with the court, and then you can get a judgment from that agreement. That's a great way to stay out of the courtroom.
What about you?
One of the things that I like to employ when we're dealing with privacy is the agreements incidents of the divorce, right? You get your divorce decree and you keep all of the important stuff out of the divorce decree. As most people know, divorce decree is a public record, right? Anybody can go down to the courthouse and look at someone's divorce decree. When you have an agreement incidents of the divorce, you're keeping out the actual property division, the accounts, the property, all of the things that are important. You're keeping them separate from the divorce decree. So nobody can really see what you guys ultimately agreed to. Now, obviously that comes towards the end once you get a settlement, right? Or something that you employ, I guess, during the process of it would be mediation or even an arbitration. So you could arbitrate it, meaning you could have a private trial, if you say, in front of an attorney, a judge. They can make the decision. And then once you have your divorce decree, you do an agreement incidents of the divorce. And now really nobody knows, right? Because only the people who were in the room at that time will know ultimately what the final divorce is.
The other thing too, just to piggyback on both of your ideas, which are great, during the process, we kind of have an interim process where we're exchanging information, and it may be, financial information. It probably is financial information, which is highly sensitive. There could be some sensitive topics that are addressed in the course of the divorce, and because you still have to make your claims and you still have to advocate for your client, even if you're doing it respectfully. Is potentially entering into a confidentiality order with regard to the documents that are exchanging place, or even the interrogatories that are being answered, even the request for production. All discovery can be under a confidentiality order, and just getting a really tight confidentiality order with some significant repercussions if it's breached, just to keep everybody quiet and respectful in the process.
Have either of you ever had to handle a situation where the courtroom is a public space, and we are required to keep courtrooms as public spaces, but you don't want to have your trial in front of or in a public space? What have you done? Has anybody ever had that scenario to happen, whether it's a trial or just a contested hearing or even just an appearance, where your client would draw attention if they were walking through the courthouse?
For me personally, the couple of times that's happened to me, usually by the time you move forward on a hearing, the courtroom's cleared out. So, and then also utilizing things like an arbitration instead of having a trial. I mean, for ancillary hearings prior to the trial, your client doesn't necessarily always have to come with you, and you go on your own, and or using arbitration or.
And to piggyback on that, you can actually remove the entire case to a special judge and have a special judge hear the entirety of the case, which would be ancillary hearings, which would be discovery disputes, which would be final trial. It's obviously a more expensive option, but it does provide the confidentiality. And then you're on your own, your own schedule. So if you've got a client who is traveling or busy for work or has a different schedule, and then they get to kind of dictate when and how quickly the trial moves along, which may be a better option depending on the client.
All right. So where do attorneys commonly underestimate the impact of public records, media access, and digital exposure for their high-profile clients? Misty?
I think it's one of those things where, for me, it's been the client not really telling you that something has happened. One of the worst things for me as an attorney is somebody else telling me something my client did. right? Me hearing something for the first time from somebody else, or reading about it from somewhere else as opposed to from your client. And so I think that it's imperative that you have those conversations with your client in the beginning of the case. We talked about notifying them of social media and conversations and things like that, but also of the importance of making sure I know first, right? So that I can help try to mitigate any situations that may have come up before they become a problem. And so I think that that's one of the things that we underestimate is making sure we have that close and constant communication with our clients who are high profile, so that we are on top of all the things that's happening. Because you can't control people, right? And you can't control situations, and things happen, but knowing that they have happened as soon as you can really can help the client in the long run, I think.
Yeah, as opposed to finding it out on the news, maybe.
Right.
Maybe.
Yeah.
Yeah.
And another thing to think about too, as the practitioner in the process, is that even if we do things like arbitration or collaborative law and like using a special judge, you still have to file pleadings in order to get the case on file. And sometimes that's enough to tip people off. And so I think having the wherewithal when you file pleading, just because you can doesn't mean you should put all of everything in at least the initial pleadings, because you can always amend your pleadings if you need to and it becomes necessary. But at the start, just making it as statutorily vague as you can helps protect, and especially if kids are involved in the divorce.
And you also have the right, something that I think a lot of people don't think of, is you have the right to motion the court to seal certain documents, right?
You do.
Affidavits or certain things that provide more information. You can always petition the court to seal that so that it's not a public record and so that everybody doesn't have access to it.
Absolutely. So how do wealth, influence, and public image create power imbalances in high-profile divorces? Yasmin?
My thought process on this is, I think sometimes if somebody's very high profile or is well known in the media, I think there's a subconscious feeling that maybe the court or even attorneys give a little deference to that person, and there's just automatic bias for the high profile person versus the no profile, maybe non-earning spouse in the divorce. And so you may have some underlying just bias, the way you treat it, depending on who you represent, depending if you're the judge, and that's something to really take into consideration in how you handle the case. So making sure if you represent the non-earning spouse and the not person who's not high profile, making sure they're crisp, they're educated on the system, they know what they're going to do if you have to have them come in to testify. You've gone through it and woodshedded them. You've gone through the testimony with them. They understand all the different nuances, so they come across confident and crisp, and to kind of counterbalance just the weight that celebrity or high-profile person's going to have in the courtroom.
And I think knowing your judge too, because I do think that there are probably some certain judges that the pendulum may swing the entire other way, as that they want to prove that they're not easily swayed by, fame and fortune. And so they may actually be harder on your client. And so using the strategies that you talked about, making sure that you don't give the judge any reason to come down hard on your client, making sure they're educated, making sure that they're clean and crisp with their testimony, making sure that they offer appropriate courtroom decorum, I think is really helpful in order to kind of keep that pendulum centered, because sometimes you just don't know how a judge is going to respond to it.
Yes, I've actually had judges who I thought gave way too much deference to the high-profile person, and I was a bit dismayed and a little bit disappointed, but we won't talk about that either.
Well, if you represent the high-profile person, making sure they come across being modest and respectful in the courtroom and not arrogant, and also handling it the other direction too.
Absolutely. All right. What safeguards help ensure fairness when one party controls the financial resources in a high-profile matter? Misty?
I think, if I understand your question, what safeguards ensure fairness? I think transparency on one side and gathering information, getting as much information as possible on the other side. I think having an understanding, kind of full circle on all the things that we talked about, having a good understanding of that person's value, of that person's property, employing an expert if necessary to analyze it. I mean, sometimes one thing that has happened or that I've experienced is people who purchase property in other people's names. Right, because they don't want everybody to know that Tom Cruise owns this winery, right? So, making sure that you have the information. I don't know that Tom Cruise owns a winery. I'm just saying. Making sure that you have all of the information necessary in order to make sure everything comes on the table.
I think using our, the discovery tools that we have. In issuing discovery as you would in any case and holding feet to the fire. And because we do have that outlet, and I think that the courts will ensure that you get the information that you need with motions to compel and stuff like that. And again, if you want to keep it out and get a, more tailored approach to the litigation process, see about getting a discovery master, hiring a discovery master. And I mean, it doesn't, necessarily have the teeth as the court does, but I think they're more accessible and can really get down into the weeds on a lot of this stuff. And then that way you're I think insured. I wouldn't say more, but at least more efficiently that you can get the information that you need. And a lot of times, if you hire a discovery master who's a practicing attorney, they understand the importance of certain documents and why you would need them. And so there's a level of understanding that I think is helpful in that process.
Discovery masters are quite pricey, though. So you have to prepare your client for what that's like.
But there's also a price to privacy, too.
There's absolutely a price to privacy. All right. So when a divorce becomes high profile, and when I ask when a divorce becomes high profile, let's say you have a person that wasn't high profile and then they did something that became high profile. Either they had a TikTok that went viral or they all of a sudden became a social media influencer, which they didn't intend to, but they did something in the midst of the divorce that all of a sudden now brought attention to them. What immediate steps should the legal team make to control the narrative and prevent reputational harm?
Tell them I told you so. Stop posting on... No. But it's, pulling back. Let's let the dust settle, whatever that means. Whatever crisis you have to control, just fly under the radar for a little while.
Okay. Anybody else have anything different that they would do?
I think employing all of the things that we've talked about. So maybe it didn't start off this way, right? Maybe we didn't start off having to do confidentiality agreements, or maybe it didn't start off with us gearing this case to arbitration as opposed to litigation in the court. But those are things that you can do through the process. It doesn't have to be in the beginning. You don't have to make the decision at the beginning that you're going to arbitrate a case, right? You don't have to make that decision early on. It could be something that you implement in the middle of the case. And so now I've learned that my client or the other party has done something that's egregious and this is going to be high profile, communicating with the other attorney to figure out what we can do to best mitigate this situation and maybe pull it out of the court system. Maybe now go to arbitration. Hey, let's mediate, let's try to get this case mediated or do these things that we need to. So it doesn't always have to start at the beginning. It could definitely start in the middle.
And I'm going to chime in on top of what Misty just said and say, I think also another thing that needs to get emphasized is good client control. And I really mean that. That means your client's the one that blew up something and all of a sudden is getting some kind of media attention, making sure they are doing everything appropriately, not making posts, not making comments, to the press or whatever, and having good control. And maybe that's a reason to get off the case if they're not, you're not able to have that kind of client control. And if you represent the other party, having realistic conversations with them about where the trajectory of the case is going, considering things like arbitration or a special judge, and doing some damage control.
And on the damage control, I mean, depending on the level of egregiousness or the money that's involved in the case, I mean, I'd even consider bringing in, a PR consultant, somebody who can help with, if the person doesn't already have one, somebody that can help with crisis control. I mean, I think we use jury consultants on occasion, and I don't think that that's much different than, your public may not be, public is the judge. But it's also, I mean, your audience is the judge, but also the public. And for our clients and juries, it's the jury. It's on a smaller scale, but it's, same concept as having somebody come in. It's a third party looking at it from a purely, what are people going to think of you, and how do we control that?
Well, I actually had to hire a crisis manager, so it was a quite interesting experience. I've only had to do it once, thank goodness. However, they do see things very differently than us. Their goal is not what to do to protect assets. Their goal is not what to do to protect the community estate. Their goal is only to protect the high-profile person and their reputation, and to manage that. And so sometimes there were times where we just didn't see eye to eye on, what this was supposed to look like. And it goes back to what you said about, client control. Like, you got to tell your client too that, okay, I get that we together made a decision that we were going to hire a crisis manager, but we together are going to control the crisis manager, because what we're not going to do is allow the crisis manager to create a situation that is more challenging for us once we end up in court. Because my judge in that case did see all of why I needed a crisis manager and let me know exactly that. So, all right. What additional considerations arise when children are involved in high-profile divorce cases?
I'll start by just saying, making sure that the children are not put in the middle. And whether it's high profile or not high profile, that happens all the time. I mean, parents, unfortunately, put children in the middle all the time, and they are pawns in the chess game. So making sure that you're not having good client control, telling your client not to put children in the middle. Also making sure the parents are having conversations with the children about their social media and what they're posting, and controlling that, and maybe seeing if the family as a whole needs therapy, if the children need individual counseling, whether or not you want to get an amicus on board to help, or a parent facilitator, figuring out what you might need to help with managing the children through the divorce process as well. So I would start.
I mean, I think that because of like the added layer of the potential media coverage in a high-profile divorce case, those things live on forever online. And you may have a 2 or 3 year old child during the course of your divorce. And I think it's important for people to remember they're going to grow up and they're going to be able to look at this stuff online. And I think that's true with every divorce, but specifically when you have that added layer of potential media coverage, that, let's keep in mind that the children are the ones that are going to be reading about mom and dad, and they're involving the children in their divorce.
Mm-hmm. Yeah. I mean, I definitely think that it adds an additional layer to it. And I like what you said about the parenting coordinator or parenting facilitator. I think that those are really good options to employ, when you have these high profile cases and there are children involved, because those are private, right? And they're not, though they can come into court, they're not something that you're going to see in court. These are going to be private sessions with the parents, with the children, to try to help them to navigate through this process. And so a lot of people are not familiar with parenting coordinators and parenting facilitators and don't utilize them. And this would be a perfect example where they could be very useful.
I imagine it's very difficult for children when they're in their own space, and images and comments about their parents and their ugly divorce is popping up and scrolling across their screen. So protecting the children is obviously one of our main concerns.
Yeah.
So how do you structure long-term agreements to minimize future public exposure and protect those same children's interests.
I mean, I think you could do it. I've seen and done confidentiality orders that go into the future as part of the divorce, and it's contractual, but it gives people recourse if something comes out. And again, and getting making sure that it covers the things that you need to cover, and of course, there's always going to be loopholes and stuff, but it gives people a sense of comfort to know that there could be recourse if things get out. But I think that doing a confidentiality order that extends beyond the divorce is a good way to do that.
Non-disclosure agreement. So not even involving children, just between spouses at the end, to protect certain information that's been relayed or something that the other party knows it doesn't want dispersed outside of the confines of the actual litigation. It's another tool, but there is no 100% method, foolproof method for any of this stuff, especially with the way social media is today and the World Wide Web and AI. And it's just, but those are things you can try to do to minimize damage.
Something else I think people should use are these mandatory arbitration, mandatory mediation clauses. I've seen in orders, not just high profile orders, but before you go and file something, you have to mediate this issue first, or before you go and file a new lawsuit, or before you try to enforce this, you have to arbitrate this issue. Those are ways that we can address now future conflict and continue to keep them out of the public eye and continue to minimize the future exposure.
Something I often like to use are agreed permanent injunctions. So injunctions from discussing the litigation with the child, injunctions from putting the child or the issues regarding the child on social media, injunctions from, even I have used where we had an injunction about having the children on social media at all. So I like the idea of it. The language that's written is pretty strong now. Like you said, Yasmin, still there's an agreement, and we are hoping that everyone will honor the agreement. But I think that there is some pretty strong language there. And I do think that the courts have remedies and tools available for, malfeasors who are just consistently doing the wrong thing. And sometimes, that can be a custody shift. So I think that there are at least some incentives for people not to continue that bad behavior.
And just said, play devil's advocate, because can't help myself. The problem now, thinking this through, is like you put these things into play and you're saying, somebody's breached that contract. In order to say somebody's breached that contract, you now have to file a court proceeding and bring everything to the forefront in order to argue about it. So I don't know, maybe there's a better solution out there that hasn't been fully investigated, but hopefully those kinds of things would at least act as a deterrent.
Maybe. I'm just trying to think. I mean, you're right. Like what? But I feel like what if we went to arbitration on a situation like that, right? And that as part of the arbitration, it is that a custody shift could be made. Then if you violate, if you put that in and you agree to arbitrate that issue, I think it holds up.
Yeah. No, I mean, I do think that the arbitration clauses would hold up in an agreement, contractual arbitration clauses.
All right. Well, ladies, I think that we have tackled this topic in a very reasonable, fair, and fluent manner. And I want to thank each of you for taking the time to come. Thank you for spend some time with us here on the Bastine Brief. And to our audience, thank you for watching. We hope that you've learned something from each of these beautiful ladies. Take care.